Hi, I'm Denise and you're watching Law with Denise. In this video, I'll be looking closely at the House of Lords case of McLoughlin and O'Brien and others, 1983. This video includes a look at the facts of the case. I'll briefly mention what was decided at first instance in the Court of Appeal, and then we will look very closely at the submissions put forward by the appellant and the respondent to the House of Lords before looking at what each of their lordships said and decided in this case. Now, if you are looking for a brief case summary of McLoughlin and O'Brien and others, I do have one, so that's in a separate video, and the link to that is in the description. What exactly are the facts of McLoughlin and O'Brien and others 1983? Well, Mrs. McLoughlin was the appellant. Mrs. McLaughlin's family, that is her husband and 3 of her children, were involved in a road accident on October 19, 1973. They were in a road accident with O'Brien, the first respondent. O'Brien was driving a lorry and her family was in a car and they had a collision. Now, our second respondent were the owners of O'Brien's lorry, A.E. Docker and Sons Limited. Then there's a third respondent, and this respondent is Raymond Sygrove. Now, Raymond Sygrove was also driving a lorry, and Raymond Sygrove's lorry had been in a collision with O'Brien's lorry before O'Brien had the collision with Mrs. McLaughlin's family on October 19, 1973. And then the fourth respondent was Ernest Doe and Sons Limited, and they are in the story because they owned Raymond Sygrove's lorry. So there we have 4 respondents and our appellant, Mrs. McLoughlin. With this case, this is not an issue about whether or not the respondents were negligent. It was agreed that there was negligence, and the respondents accepted that they owed a duty of care to Mrs. McLaughlin's family, who were actually involved in the accident. But throughout the case, they argued that there wasn't any duty of care owed to Mrs. McLoughlin. Where was Mrs. McLoughlin on October 19, 1973 when the accident occurred? Mrs. McLoughlin was at home, which was 2 miles away from where this took place. She was told about the accident by a friend, Mr. Pilgrim, and then 2 hours after the accident, so around 6 p.m., Mrs. McLoughlin is in the hospital and she visits her family. It is what Mrs. McLoughlin sees and hears in the hospital 2 hours after the incident which causes her psychiatric injury. Now, what is it that Mrs. McLoughlin sees and hears? She sees and hears the sobs and screams of her family. She sees her husband is injured. She sees her son, George, lapse into unconsciousness, and he suffered a concoction. Her daughter, Kathleen, has also suffered a concoction. She also learns, unfortunately, that her younger daughter, who was not even 3 at the time, actually lost her life in the accident. So this is a very, very terrible situation for Mrs. McLoughlin. And as a result, she does suffer psychiatric injury. 3 years after this, so in 1976, Mrs. McLoughlin starts a case. Now, at first instance, Mrs. McLaughlin's case fails. And why does Mrs. McLaughlin's case fail at first instance? Well, the judge at first instance says, in order to recover damages for your psychiatric injury, you would have to demonstrate to the court or convince us that injury to you was reasonably foreseeable. That means that we have to be convinced that the defendant could have reasonably foreseen that his negligence, or rather their negligence, could have led to your psychiatric injury. So case dismissed. She lost. Mrs. McLoughlin did appeal, and this appeal went on to the Court of Appeal. Now, what did the Court of Appeal say? It was agreed that injury to Mrs. McLoughlin was reasonably foreseeable. However, Mrs. McLoughlin doesn't succeed in the Court of Appeal either. Well, she doesn't succeed in the Court of Appeal because the Lord Justices say, yes, injury to you was reasonably foreseeable, but there was no duty of care owed to you. And if there's no duty of care owed to you, then you cannot recover damages. So appeal dismissed. What the Court of Appeal was talking about was the fact that Mrs. McLoughlin did not see the accident with her own eyes, and that she was not close by the accident. So precedents, namely Hambrook and Stokes Brothers 1925, had indicated that for recovery of damages, for demonstration that a duty of care was owed, a plaintiff such as Mrs. McLoughlin in these types of cases would need to demonstrate that they had seen the accident which caused them the psychiatric injury, or they were close by to it. So because she didn't fit into that category which the law said you needed to fit into in order for a duty of care to be owed to you, in order for you to recover damages, the Court of Appeals said, we can't really help you because that is the law. Looking at the law, there is no duty of care owed to you, Mrs. McLoughlin, even though injury to you was reasonably foreseeable. We're dealing with a common law system, right? The Lord Justices are part of a common law system, so they could have extended the law in order to allow Mrs. McLoughlin to recover damages. And the reason they said they could not do that, being they could not extend the law to allow for Mrs. McLoughlin to recover damages, was because of public policy reasons. They said those reasons were preventing them from extending the law. Now, what exactly did they mean by this? What the Lord Justices were concerned with was the opening of the floodgates with cases similar to this, some without merit, if they had extended the law. So what they were concerned with was, okay, if we allow for people to begin recovering damages even though they were not at or near the scene of the accident when it occurred, and they unfortunately suffered psychiatric injury, what we're going to have is a lot more cases coming into the courts. And then obviously with a lot more cases coming into the courts, we can predict all the possible problems. Overload of cases, inability to deal with them. Another public policy reasons that the Lord Justices said was preventing them from extending the law was this concern that if they were to extend the law, there would be this financial burden on tortfeasors, because there would be more possibility for tortfeasors to have to pay out damages to claimants. So they said, looking at the public policy issues related to these types of cases, unfortunately, we are not able to extend the law, so appeal dismissed. Now, Mrs. McLoughlin made a further appeal, and this appeal went on to the House of Lords. Before we look at what was decided in the House of Lords, let's have a closer look at what Mrs. McLaughlin's legal representatives put forward. So Mrs. McLaughlin's legal representatives argued, firstly, that injury to Mrs. McLoughlin was reasonably foreseeable. And they argued that it was reasonably foreseeable based on the precedent Wagonmound 1961. They said if you look at Wagonmound 1961, what that case asked for in order to demonstrate if injury is reasonably foreseeable to a plaintiff is that it was foreseeable that possible injury could occur as a result of the defendant's negligence. And they said if you look at it, you look at the facts of this case, that is evidenced. It is evidence that there was possible injury foreseeable to Mrs. McLoughlin as a result of the respondent's negligence. Mrs. McLaughlin's legal representatives also said to the House of Lords, when you're making your decision about foreseeability, yes, we want you to look at, or we think you should look at Wagonmound 1961. But when you're doing that, do not look at it alongside Hambrook and Stokes Brothers 1925. And they said to the House of Lords, do not consider it because when Hambrook and Stokes Brothers was decided, our understanding of what was foreseeable was not as up to date as our understanding of what is foreseeable now in terms of psychiatric injury. So, in addition to establishing or trying to convince the House of Lords that injury to Mrs. McLoughlin was reasonably foreseeable, her legal representatives said to the House of Lords, when it is established, as we have demonstrated here, that foreseeability is reasonably foreseeable, normally a person gets their damages. They said the only reason that they would not get their damages is if there is some compelling public policy reason which prevents the court from giving them their damages. So if we go back a bit and say, okay, these public policy arguments are not convincing, and since they're not convincing, and since we have shown you that Mrs. McLaughlin's injury was reasonably foreseeable, she should get her damages, because it's only if there are compelling public policy reasons in place why a person would not get their damages. So let's have a look at what the respondents put forward to their lordships. So their submissions were as follows. First, the respondent said, ooh, no foreseeability is established here, your lordships. And why not? They said, look, the test for foreseeability is actually that it was foreseeable that real risk would occur, that there was real risk of injury to the plaintiff. And they said, when we look at the facts, right, there wasn't any real risk to Mrs. McLoughlin. And they were applying the Wagon Mound number 2 case. So remember, the appellants applied Wagon Mound 1, and their argument was that in order to establish foreseeability, all we're looking for is the foreseeability of possible injury or shock. The respondents are saying, actually, what we're looking for is foreseeability of real risk. So no foreseeability has been established in this case. And then the respondent said, even if we claim or we accept that there was foreseeability of injury or shock to Mrs. McLoughlin, there wasn't any duty of care owed to her. And how did they come to the conclusion that there was any duty of care owed to her? They refer to Hambrook and Stokes brothers, 1925. Now, remember, the appellants said to their lordships, they did not think Hambrook and Stokes brothers should be considered. But the respondents are saying, consider Hambrook and Stokes brothers, 1925. Why? Because Hambrook and Stokes brothers, 1925 said that, yes, a third party can recover damages if they are in fear of the safety of others, but they need to have seen the incident which caused them to be in fear of the safety of others, or they need to have been close to it. Now, with Mrs. McLaughlin's case, the respondents were saying to their lordships, she was not at or near the scene of the accident. She did not see the accident. She was 2 miles away at home. So when we apply the precedent, Hambrook and Stokes brothers, 1925, the respondents are saying, there is no duty of care owed to Mrs. McLoughlin. They also said to their lordships, let us look at Bourhill and Young, 1943. They said to their lordships, when you look at Bourhill and Young, 1943, a House of Lords decision, and you look at their lordships' opinions, you see that the proximity of the plaintiff to the scene of the accident is important. And then they say, okay, let us have a look at Chadwick and British Railways Board, 1967. Why? Because they know that in Chadwick and British Railways Board, Mr. Chadwick was not at or near the scene of the accident, but he was able to recover damages. Okay, so if their lordships were to apply Chadwick and British Railways Board, then Mrs. McLoughlin would have been okay, right? Because Mr. Chadwick was able to recover damages as a rescuer. That's a rescuer case, which means that when Mr. Chadwick turned up to the scene afterwards, there is still uncertainty of danger going on. But they said, when you look at Mrs. McLaughlin's case, this is different. When she turns up to see her family in the hospital 2 hours afterwards, there is no uncertainty of danger. So they asked their lordships to distinguish Chadwick and British Railways Board from McLoughlin and O'Brien and others. Do not apply Chadwick and British Railways Board because they are different, they're saying. And they said, what is actually applicable is Hambrook and Stokes brothers and Bourhill and Young, 1943. And those precedents show us that it is very important for the plaintiff to have been at or near the scene of the accident when it occurred, and she was not. Therefore, there is no duty of care owed to Mrs. McLoughlin. So far I've talked about quite a few cases, and I would like to point out that I do have videos on 2 of those cases. So I have videos on Bourhill and Young, 1943, and also a video on Chadwick and British Railways Board, 1967. These are case summaries. You can either go and watch them after you've watched this video, or you can pause, go and watch them, and then come back if you think it's necessary for you to do so. The links to them are in the description. Now let's have a look at what their lordship said in response to the submissions made by the appellant and the respondents. Now in this case, we had 5 lords. They were Lord Wilberforce, Lord Edmund-Davies, Lord Scarman, Lord Russell of Killowen, and Lord Bridge of Harwich. They had to decide the following. They had to decide if injury to Mrs. McLoughlin was foreseeable, and if it were, could Mrs. McLoughlin recover damages? So was a duty of care owed to her? And if a duty of care was not owed to her, their lordships had to decide if they were going to extend the law or if they were prevented from doing so by public policy reasons. Now, all of their lordships agreed that injury to Mrs. McLoughlin was foreseeable, and they allowed the appeal, allowing Mrs. McLoughlin to recover damages. But there are some differences with regard to public policy. So their lordships had differing perspectives with regard to this public policy issue. Let's have a look at each of their opinions so that we can see where they sat with regard to the public policy issues, and also some of their opinions and perspectives on the foreseeability issue in this case. Now let's start off with Lord Wilberforce. Lord Wilberforce, as I said, all of them agreed that Mrs. McLaughlin's injury was reasonably foreseeable. So Lord Wilberforce also agreed with that. Lord Wilberforce, however, was very concerned with how the law would develop in future. So Lord Wilberforce put forward some ideas as to how he thought cases like this should be dealt with in the future. Now, I'm not going to go into those discussions here. There is another video in which I do that, because that video involves an analysis of the development of this area of law. And in that video, you will find the opinion set out by Lord Wilberforce. But what Lord Wilberforce was really concerned with was where the boundaries would lie after Mrs. McLoughlin was given her damages. He was concerned with where the limitations would be with this area of law. And for that, he proposed ways in which the law could tackle these foreseen issues. We also had Lord Edmund-Davies, who gave his opinion. Lord Edmund-Davies pointed out that he thought judges sometimes had an outdated understanding of psychiatric injury, which influenced their erroneous understanding of what was foreseeable in cases such as Mrs. McLaughlin's. So he wanted to draw a bit of attention to the fact that our development or understanding of psychiatric injury had increased, and therefore it has affected what we see as reasonably foreseeable, but that some judges were not keeping up with these developments. And because they weren't keeping up with it, that was affecting their perspective when they got cases such as Mrs. McLaughlin's. With regard to the public policy issue, Lord Edmund-Davies said that he did not believe there was going to be any substantial increase in cases if Mrs. McLoughlin were to recover damages. So he did not buy the public policy arguments. Lord Scarman, on the other hand, was quite concerned with the public policy issues. So he thought there were some issues for consideration, but he did not think it was for judges to deal with these public policy issues. He thought it was for Parliament to legislate to rectify the public policy issues that were relevant to these types of cases, not judges. Lord Russell of Killowen thought it was very clear that injury to Mrs. McLoughlin was reasonably foreseeable. And he thought, since it was reasonably foreseeable, he could not see why she could not recover damages. He also said that with regard to public policy reasons, he did not feel the fear that others seem to have about what next, what's going to happen next with the law if Mrs. McLoughlin is able to recover damages. He said he did not feel that fear, at least not enough to deny Mrs. McLoughlin damages in this case. Thus, he allowed the appeal, just like the other lordships did. And then finally, we had Lord Bridge of Harwich. Lord Bridge of Harwich also thought that injury to Mrs. McLoughlin was reasonably foreseeable. Lord Bridge of Harwich did not think it necessary for us to have some arbitrary line which told us who could recover damages, when they could and could not recover damages. Lord Bridge of Harwich thought that it was enough for judges to reach their decisions on a case-by-case basis while taking into consideration, as he put it, enlightened understandings of mental illness. So it looks as though Lord Bridge of Harwich, in addition to saying that judges can use their intelligence to reach decisions on a case-by-case basis, in addition to that, Lord Bridge of Harwich is drawing attention to the fact that our understanding of psychiatric injury is developing, and that judges could make sensible decisions while bearing in mind those developments, but do it on a case-by-case basis. Thank you so much for watching this video until the end. We have gone through the facts of McLoughlin and O'Brien. We've gone through the arguments, or submissions rather, put forward by the appellant and the respondents, and we've looked closely at what each of their lordships said in this case. Until next time, take care and bye-bye.